Good morning, students. Today we are discussing about concept of child rights. Child is a gift of God. Child creates a meaning of life. Childhood age desire never change even when we obtain a higher position. Most of the people are very eager to see the aeroplanes fly in the sky. We stopped the vehicle to see the train. According to international law, a child means every human being below the age of 18 years. This is a universally accepted definition of a child and comes from the United Nations Conventions on the Right of the Child, an international legal instrument accepted and ratified by most countries. Children being the population of the country, it is essential that there must be strict laws to protect their rights. They don't have the thinking capacity as that of an adult. A child who cannot distance right and wrong. Though there are many provisions protecting children, they are exposed to many atrocities. Children are generally associated with terms like innocence, freedom, joy without any kind of obligation of adult life. But they are usually vulnerable to various forms and exploitation and crimes. The fact that they are young and vulnerable establish the fact that they need to be protected from the cruelty of the outside world. The future of the children is the future of the nation, so protecting them and their rights is essential for a nation like India. But in India, only during the 20th century, the concept of child rights emerged. Earlier, the father had absolute right and control over children was an established common law doctrine. This way, a practice that was there for centuries, no proper law was there. The Convention on the Rights of Children in December 1992 from the 20th century. Children got some proper right in place for them and the shift or changes was significant. The concept of social justice, empowerment and equity emerged. There are, however, other laws that define a child differently and are yet to be brought in conformity with the UNCRC. This means all persons in village, town, city below the age of 18 years have to be treated as children and need for assistance and support. Now we have an idea about the age of a child. Concept of child and child rights. Children are always prone to all the crimes. They can be both the victim and the culprit. The environment in which a child grows is very important. Children are the future of any country. If they are not given proper education, health, or protection, it will affect our country. It is our duty to protect the children. The most basic needs of the children are referred to as rights. Child rights are specialized human rights that apply to all human beings below the age of 18. The child rights human beings below the age of 18. According to United Nations Convention on the Rights of the child rights are minimum entitlements and freedoms that should be afforded to all persons below the age of 18 regardless of race, color, gender, language, religion, opinions, origins, wealth, birth status or ability, and therefore apply to all people everywhere. The specialized rights found by them are right to survival, protection, participation, and development. Definition of child and child rights. Etymologically, the term child comes from the Latin infant, which means the one who does not speak. For the Roman, this term dignities the child from its birth up to the age of 7 years. According to international law, a child means every human being below the age of 18 years. Child means any person who has not completed 18 years of age. A child means every human being below the age of 18 years unless under the law applicable to the child majority is attained and earlier. Children's rights are economic, social, cultural rights such as the right to education, the right to a decent standard of living, the right to health, etc. Children or young people have the same general human rights as adults and also specific rights that recognize their special needs. Definition of a child under various laws in India. History of India, rights in Tamil Nadu and India. All persons below the age of 18 are children. Childhood is a stage through which every human being passes. Children have different experience during childhood. All children need to be protected from abuse and exploitation. In India, after passing the Juvenile Justice Act 2000, any person below the age of 18 is considered as a child, as the mental state of adults and children are different. Therefore, there is a need to treat them separately under the different purview of law. Legal definition of child. The term child is not defined in the Indian Constitution according to Article 1 of the United Nations Conventions on the Rights of the Child 1989. A child means every human being below the age of 18 years unless under the law applicable to the child majority is attained earlier. The Act defines child as any person below the age of 18 years and provides protection to all children from all kinds of assaults, sexual assaults, harassment, and pornography. According to international law, a child means every human being below the age of 18 years. This is a universally accepted definition of a child and comes from the United Nations Conventions on the Rights of the Child, an international legal instrument accepted and ratified by most countries. India has always recognized the category of persons below the age of 18 years as a distinct legal entity. That is, especially people can vote or get a driving license or enter into legal contract only when they attain the age of 18 years. Marriage of a girl below the age of 18 years and a boy below 21 years is restrained under the Child Marriage Restraint Act 1929. Moreover, after adopting the UNCRC in 1992, India changed its law on juvenile justice to ensure that the person below the age of 18 years. History of legalization for protecting child rights in India, the beginning. First legalization pertaining to children in India was the Apprehensions Act of 1850. This legislation, however, did not create a separate juvenile justice system but worked within the adult justice system. It was the Reformator Schools Act 1897 which separated for the first time in India children from adults in the criminal justice system. First one Children's Act. Following the recommendations of the Indian Jails Committee 1919-1920, the Madras Children Act 1920 was introduced, which became the first Children's Act in India. It was a provincial and covered the Madras Province, the Bengal Children Act and the Bombay Children Act and many other legislation then followed in 1960. The Government of India enacted the Children's Act, which was applicable in Union territories. All these legislation were replaced with the enactment of the Juvenile Justice Act 1986. The Juvenile Justice Act enacted in 1986 was the first juvenile law in India, which was uniformly applicable across the country. In order to comply with the provisions of UNCRC, the Juvenile Justice Act 1986 was amended and been acted as the Juvenile Justice Act in 2020. The Juvenile Justice Act in 2020. It was further amended in 2006 as the Juvenile Justice Amendment Act 2006 and in 2011. The juvenile justice system in India today is governed by this important pieces of legislation. The Union Government in June 2014 has introduced proposals to amend the Juvenile Justice Act. Prohibition of Child Marriage Act. The Child Marriage Restraint Act was first enacted in British India in 1929. It was amended in 1978 to overcome the shortcomings of Child Marriage Restraint Act. The Government of India enacted the Prohibition of Child Marriages Act 2006, which came into effect from 1st November 2007. Under this Act, a child or minor is a person up to 18 years in the case of girls and 21 years in the case of boys. The solemnization of child marriages in a cognizable and non-bailable offences. Child Labour Act 1986. The CLPR Act is the foremost legislation on preventing child labour. The CLPR Act replaced the Employment of Children Act 1938. Under this Act, a child means a person who has not completed the age of 14 years. The Act prohibits child labour in certain specified hazardous occupation and manufacturing processes. The Act is not applicable to processes carried out by families with their own members. The Act does not allow children to work between 7 p.m. and 8 a.m. Children are also not allowed to work overtime or in more than one establishment in a day. No child is permitted to work for more than 6 hours each a day. Children should be given 1 hour rest after every 3-hour duty. The Act was amended on 10th October 2006. Fifth point, Commission for Protection of Child Rights. The Government of India appointed an expert committee under the chairmanship of Justice V.R. Krishna Iyer for drafting the National Commission for Children Bill 2000. Based on this draft, the government enacted the Commissions for Protection of Child Rights Act 2005, which was notified in the Gazette of India on 20th Jan 2006, Act number 4 of 2006. These commissions were set up for proper enforcement of children's rights and for the effective implementation of laws and programs relating to children. The rules for implementation of the provisions of the Act in respect of the National Commission for Protection of Child Rights were notified on 31/7/2006, and the National Commission for Protection of Child Rights has been constituted. Many state governments have also set up state commissions for protection of child rights. The commissions are authorized to initiate steps to ensure child protection and child rights. Sixth point, ban on corporal punishment. The Supreme Court of India banned corporal punishment for children on December 1, 2000, when it directed the state to ensure that children are not subjected to corporal punishment in schools and they receive education in an environment of freedom and dignity free from fear. 7th one, Right to Education Act. The Right of Children to Free and Compulsory Education Act 2009 came into force with effect from 1st April 2010. The RT Act aims to provide for free and compulsory education to all children of the age of 6 to 14 years in a neighborhood school till completion of elementary education. 8th one, Protection of Children from Sex Abuse. The Protection of Children from Sexual Offences Act 2012 came into effect on 14 November 2012. This act aims to strengthen the legal provisions for the protection of children from sexual abuse and exploitation. From the first time, a special law has been passed in India to address the issue of sexual offences against children. It provides protection to all children under the age of 18 years from the offences of sexual assault, sexual harassment, and pornography. In India, child welfare and development are paramount concerns for any society, and the government of Tamil Nadu has taken significant strides in this direction. With its comprehensive Tamil Nadu State Policy for Children of 2021. While the state has made commendable progress in various indicators, it acknowledges that certain challenges persist, such as child marriage, child labor, crimes against children, and juvenile delinquency. This policy is a crucial crimes, children, and juvenile delinquents. This policy is a crucial step towards addressing these issues and ensuring the well-being and safety of Tamil Nadu children. Strategic approaches. Aligned with the UNCRC, the TNPSC emphasizes a multifaceted approach encompassing survival, growth, development, protection, and participation. By addressing these dimensions, the policy endeavors to create a comprehensive framework for enhancing children's lives.